All right, and now, without any further ado, Professor Jacobson.
You made it clear it's not going to be live.
This event will not be live streamed due to the audience members. Without any further ado, Professor Jacobson, thanks so much.
Thank you very much, Peter, and thank you to Pietro when he gets here, as he's required, for arranging this event. I'd like to also thank the other members of the Conservative Libertarian Union. This is the second time they've had me on campus. The last time was in 2014. We'd like to thank Students for Liberty. We'd also like to thank Dean Chanette for attending, as he did also attend my 2014 speech. So I must have done a really good job because he's come back again. Thank you. I would also like to thank President Bradley for supporting my ability to appear here today. There was a request to cancel my appearance from the Vassar Student Association Executive Committee, and I'm very glad that she stood by my ability to speak here. Of course, the President, standing by my ability to speak, the groups inviting me, do not mean they necessarily endorse all my views. They may not. And that's really one of the key foundations that I'm going to stress tonight when talking about the First Amendment and the right to free speech, is that by protecting someone's right to free speech, you are not endorsing their ideas necessarily. And I'll get into that in much greater detail. I am glad that we have a great turnout. I was so concerned that nobody would show up, but I guess with all the controversy on campus this week, people decided to show up, and I'm glad, because I don't expect everybody to agree with me. If you've seen any of my prior speeches, I'll tell you right now what my style is. My style is not to tell you what the right thing is. My style is to give you some things to think about, to express my views, and to hopefully get people thinking. And for those who come in predisposed to agree with me, I'm glad you're here. I hope I can give you information that bolsters that. For those of you who maybe you're on the fence and don't really know what I'm going to talk about, don't really know what the free speech issue is, hopefully I can give you some things to think about to help you make your decision. And the people who are dead set against me being here, who are protesting my being here, I hope you'll listen to what I have to say respectfully, because I respect your right to protest, and I hope you'll respect my right to speak. And I hope that there are some things there that I'll say that will make you consider your positions, even if at the end of my lecture I haven't changed your mind necessarily. President Bradley issued a statement in September of 2017, September 17th, regarding the intellectual atmosphere on the campus. And I think that it's an important statement because it highlights the tension between free speech and other considerations that are legitimate considerations on private college campuses. And I'll explain to you why private is very important constitutionally. And in that statement, I'm just going to read part of it. She said, students are similarly encouraged to explore any and all issues and speak out about them. Those who disagree with their views are equally free to take issue with them. And so that's an important concept of the concept of free speech. Freedom of speech does not mean freedom from criticism. My freedom to speak here does not mean I'm free from criticism. Your questions are not free from criticism, and what you write are not free from criticism. A lot of people mistake criticism as an attempt to silence somebody, and that's not. And that statement takes that into account. But she goes on. I condemn any expressions that incite violence or lawlessness and stand behind the right of all members of the community to speak out on issues of importance to them. She continues, quoting from the Vassar Faculty Handbook, that Vassar is dedicated to freedom of inquiry in the pursuit of truth and is vigilant in defending the right of individuals to free speech. This may include the introduction and discussion of controversial and challenging matters both within and beyond the classroom. That concept of free speech is very important because it goes to why I came to Vassar. So I can put aside a lot of the misconceptions that have been circulated in emails and social media. The notion that I came here to target people, the notion that I came here to justify or defend hate speech as such, the notion, God forbid, that I'm a neo-Nazi or a white supremacist is absurd. It's the exact opposite of what I am. I don't know how these rumors got started. I know they were spread, and I just hope you'll listen to my speech and draw your own conclusions when I'm done. The tension that President Bradley, or that was reflected in her statement, is a tension that I think has become worse since Charlottesville. We all know what Charlottesville was. You know, watching those people with the tiki torches was nauseating. It was abominable, but they weren't a public campus. And under the Constitution, they had a right to be abominable and nauseating. And that's one of the things I want to talk to you about tonight. And that's why I included Charlottesville, and that was my idea of the original title. And the original title of my speech was Hate Speech is Still Free Speech, hate speech in quotes. Hate speech is still free speech, even after Charlottesville. That title, for me, focused very distinctly on the problem of balancing on a private campus. That statement was not a statement of opinion by me. That statement was a statement of fact as to the status of the law. Hate speech, and I'll go into this more, speech denigrating groups may be hateful, but it's protected under our Constitution. And then if you read the explanation of what I'm going to talk about, so after that initial title, it was, should Vassar ban hate speech? Who decides what hate speech is? And that I would argue in favor of freedom of speech. I don't know why that was controversial. I really, truly don't. And the fact that people would try to prevent me from speaking about those principles was shocking to me. It really was. But I'm here. The name got changed, not because I thought the name needed to be changed, but it was pointed out to me that the original proposal put in for my appearance that was approved by VSA for funding had a different name on it. And various people felt that it would be proper to go forward with the speech, not with what I had proposed, but what the students had filled out when they submitted it for approval. So that's why we changed it. I still think my original title was an appropriate statement of the law, which helps us focus on what the problem is. I'll talk to you in a little while about some Supreme Court cases, but I'll read for you right now a short passage from a very recent 2017 case, Mattal v. Tam, also known as the Slants case. And that was a case where an Asian American band wanted to trademark the name The Slants, and the trademark office denied it on the ground of a provision in the trademark law that it denigrated a group of people. And the Supreme Court overruled that. And I'll read you a passage that was written by Justice Anthony Kennedy, kind of the swing vote, but was signed on to by 3 of the liberal members on the court. This portion of it, they had multiple decisions. Nobody objected, nobody dissented, but they wrote separate decisions. So a conservative justice and 3 of the liberal justices agreed to the language that I'm about to read to you. A law that can be directed against speech found offensive to some portion of the public can be turned against minority and dissenting views to the detriment of all. The First Amendment does not entrust that power to the government's benevolence. Instead, our reliance must be on the substantial safeguards of free and open discussion in a democratic society. the question that you have at Vassar as a private college, which is not strictly bound by the First Amendment, although I would argue you should aspire to it, if you're not strictly bound by it, is how do you weigh offensiveness versus your desire for a community in which everyone feels welcome. And that is a legitimate desire, but there's a countervailing desire to have a society in which free speech is permitted, even speech we don't like. Supporting the constitutional right to free speech is not an endorsement of the speech itself. This is a concept I think a lot of people have trouble getting their arms around and their minds around, and it's a problem that the American Civil Liberties Union is having right now, because the American Civil Liberties Union went to court to get an injunction to allow the tiki torch holders to march in Charlottesville. And they've come under a lot of flack because the history of the American Civil Liberties Union is defending speech to its fullest constitutional extent, regardless of how miserable and abhorrent the people are. And those are what most of the cases are. Most of the cases involving constitutional speech involve abhorrent people, whether it's the people in Charlottesville, or whether it is what's the Baptist church that goes and pickets, First Baptist Church, whatever they're called. I mean, these are the people who push things to the limit and create these issues. One thing I'd ask you to do, one of the takeaways, I like to have takeaways from my speech. One of the things I'd ask you to take away from my speech is not to live in the moment, to consider the history of the First Amendment, who it has protected, and to understand that it's a bigger issue than a particular speaker at a particular time. It's a bigger issue than a particular campus or a particular city. Don't view the First Amendment as protecting only those you disagree with. The First Amendment protects us as a society. And if you have any doubt about that, go live in a country that doesn't have the First Amendment protection of speech. I studied in one, the Soviet Union, when I was in college. You don't want to live in that sort of country. So whatever discomfort the First Amendment provides, it's something that is very valuable to us. Another takeaway, don't turn freedom of speech into a power play. That those who have the power to decide who can speak and what they can say get to do it, that might makes right. Within this campus, you may think you have the power to stifle people and to silence speech. And to some extent you do. To some extent the progressive movement on campuses has the ability to do that because they're the majority and they have power on campus. But it's not going to come as a shock to you that once you leave the gate, it's a completely different world. And beyond that gate, the second you walk out, you're in First Amendment territory. And the question is, to what extent do you want to allow that freedom that's beyond the gate to be abrogated on this campus? And I'll run through some other freedoms that I don't think you want abrogated on this campus. And the question is, just because it's a private college, you can enforce intellectual uniformity through suppressing speech, doesn't mean that you should. There are people, if you empower people to suppress speech on campus that you don't like, you lose the legitimacy of complaining when your speech is suppressed outside the gates. It's very important. When you suppress speech, you lose the legitimacy of defending your own speech outside. And in fact, the history of the First Amendment is largely the protection, at least in the US, at least in the last 75 years, the protection of progressive and social justice movements that were unpopular with the people in power, and probably still are unpopular with the people in power. And so the First Amendment has played an extremely important role. The cases involving neo-Nazis and the Baptist Church get all the headlines, but the reality is that the history of the First Amendment is a history of protecting communists, civil rights movement, the anti-war movement, and other political activities that were deemed at the time hateful by those in power. The civil rights movement by the people in power was considered hateful. But I don't think we would have wanted that speech suppressed, and that speech was protected by the First Amendment. So don't view things in the moment, that it's you on Vassar's campus here and now. There is a history to this, and there's a positive history to the First Amendment. The campus, different people have different views of what a campus should be. I've read to you President Bradley's statement of how she envisions the campus as a place of lively intellectual exchanges. I've always viewed the campus as the place that should be most free. Maybe it's the generation I grew up in, but the universities were on the cutting edge of free speech. And that's where the free speech was taking place, mostly through the anti-war movement. And those freedoms of expression were extremely important. And now there seems to be a trend on a lot of campuses to make campuses the least free place for speech. And I think that's a mistake. I would hope you would think about the campus as the freest of places, not as the least free place. The clampdown on speech on campuses takes many different forms, and I can't address all of them. There's campus speech codes. There's microaggression theory, where you could unknowingly offend somebody. There's campus judicial and disciplinary proceedings that lack due process of law. And I'm not talking about just for sexual assault cases. I'm talking about for any time you find yourself in a university system. You've got a tiny fraction of the rights that you have beyond that gate. There's a political skewing of faculty, and I know that because I'm at Cornell. I can count on one hand out of thousands of faculty members, openly conservative faculty. I'd say I'm the only one, but there's one or two people who might disagree with me on that. I'm certainly the most vocal and the most visible because of my website. And the Cornell Sun did a survey and found that 96% of the donations to presidential candidates, and I think federal candidates, state, Senate, congressional, and presidential, by Cornell faculty, 96% went to Democrats. And there was a lot of talk on campus about lack of intellectual diversity on campus. And I think that's a real problem, and that is one of the things that stifles speech. There is a tendency to demonize others as a means of shutting down speech, and a means of having your own ideas challenged. Everyone who is who's right of center now is labeled a Nazi or a neo-Nazi or an extremist. And think about whether that's really true, or is that a mechanism to try to silence people. I know from my own experience at Cornell, there are other ways that people try to silence you. I think I told the story back in 2014, it's the same story, that almost from the moment I started my website, within 2 to 3 weeks, expressing the views that I expressed, I was receiving hate mail, and if it starts with F whatever, it's hate mail, that's how I know it, harassing emails to the faculty, attempts to get me fired repeatedly over the years, threats that were serious enough that at one graduation the university assigned a detective to accompany me to graduation because of threats. So I take the First Amendment very seriously, and I am not going to let anybody shut down my speech. And I don't think you should let anybody shut down your speech. And there are limits to free speech, and I'll talk about what those limits are. But I want to talk about some other constitutional protections that I think you probably find of value on this campus. And I'm not going to cover them all, but the Third Amendment, show of hands, does anybody know what the Third Amendment is? Okay, it's my favorite amendment of them all. No soldier shall, in time of peace, be quartered in any house without the consent of the owner. So the government can't use your house to have barracks for soldiers. Unless there's a law passed about that, that they can't just take over your house. And I'm sure you want that freedom on Vassar's campus. You don't want the government, you don't want the president, you don't want the dean of faculty saying, oh, I'm moving somebody into your room tomorrow, and your one bedroom is now a two bedroom, and there's nothing you can do about it. You have no right of redress, you can't contest it. So you want your zone of privacy. So I assume that's a right that people don't want to give up on campus, to have soldiers quartered in your dorm room. The Fourth Amendment against barring unreasonable searches and seizures. So they have to have probable cause if they're going to search a car that a crime is committed. Or if they're going to, and this is a contentious area, they'll all pat you down, or if they're going to make you open your bag, or get to look in your cell phone. That's the hot topic of litigation. So, but I assume that nobody here wants their stuff unreasonably searched and seized, whether it's by the government or by the Vassar administration. So that's something we're going to protect on campus. The Fifth Amendment, in any criminal case, no one shall be compelled to be a witness against himself. I think you don't want to be compelled to testify against yourself. You don't want to be tortured into confessing. You're protected. You want that right on the Vassar campus as well. And you don't want to be deprived of life, liberty, or property without due process of law. The administration can't come and just take your stuff, nor can the government. You don't want it. The administration may not be bound by a constitutional provision, but I think that's something you would want protected, that they can't just take your stuff unless there's some process that gives them some legal right to do it. The Sixth Amendment, speedy trial, confronting witnesses, assistance of counsel for his defense. Is there anyone here who thinks that someone accused of murder should not have a lawyer? I hope not. By defending that person's right to a lawyer and to a speedy trial and to an impartial jury, we're upholding a principle that's fundamental to our society. We are not endorsing this murderer, and we're not endorsing murder. We're defending a constitutional provision that's important. Eighth Amendment, cruel and unusual punishments. You don't want to be subjected to cruel and unusual punishment. So I've gone through all of these, and the 14th Amendment, that you can't be deprived of property and liberty without due process, and you are entitled to equal protection of the laws. I assume that's what you want on this campus. So I just ask you, does anyone think this campus should be less free as to all of these other things? And if not, why should the campus be less free as to freedom of speech? The First Amendment, I'm finally going to get to. Congress shall make no law respecting an establishment of religion, that's religious protection, or you can't have state religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for redress. Everybody always complains about lobbyists. Lobbyists are petitioning the government for redress. They are constitutionally protected. But abridging the freedom of speech, what does that mean? It's kind of legally, what does it mean? It means everything is free speech except the things that the courts have held are not free speech. So it's the default. The default is that everything is free speech. What are some of the things that the cases have said are not free speech? Obscenity and child pornography, perjury, lying under oath, blackmail, threats of physical violence, solicitations to commit crimes, defamation, if someone says false things about you and you meet the legal standard, you can sue them. That's not constitutionally protected speech. Fighting words. Fighting words is getting in someone's face and verbally and through gestures threatening to punch them in the face. That's not protected speech, even if you never actually punch them. Incitement to imminent lawlessness is not protected. What is not on the list I've just read you, and what the cases make very clear, is offensive, or what we would call hate speech, is not an exception to the First Amendment. It is, therefore, protected speech. That has been held that mere words offensive words are not fighting words, because remember I said that's one of the exceptions to freedom of speech. Case of Snyder v. Phelps involves that Baptist church that everybody's offended by, and held that their speech was okay, that they have the right to protest near military funerals, as offensive as that is, and say horrible things about homosexuals. That's constitutionally protected speech, as offensive as it is. And I'll just read you a quote from that decision. Speech is powerful. It can stir people to action, move them to tears of joy and sorrow, and, as it did here, inflict great pain. The fact that speech inflicts some level of pain does not mean it's not constitutionally protected. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course: to protect even hurtful speech on public issues to ensure that we do not stifle public debate. That choice requires that we shield the Westboro Baptist Church from liability for its beginning in that case. Is hate speech incitement to imminent lawlessness, which is one of the other exceptions? And the answer is no, that it's not. The case there is Hesby, Indiana, which involved students protesting the war, anti-war students. And one of the students shouted out, "We'll take the effing street later," and was charged with incitement for that. And the court held that that is protected speech. Words amounting to nothing more than advocacy of illegal action at some indefinite future time do not come within the narrowly limited classes of speech which the states may punish. Now I'll get again to the Mattal v. Tam case, which is, in a sense, the purest case of hate speech. And I always do the quote, the air quotes, because hate speech is not a legal term. It's a term that people use, but it's not actually a legal term. It is a case of the most pure hate speech. There was nothing else going on than the request of an Asian American band to call themselves and trademark the Slants. They were denied. Supreme Court said that they could not be denied, that speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. Because remember, you may be in a position where someone considers what you said hateful, and do you want to give them the right to prevent you from speaking? It is fundamental that the government may not punish or suppress speech based on disapproval of the ideas or perspectives that the speech contains. The government may not insulate viewpoint discrimination by tying censorship to the reaction of the audience. So the reaction of the audience, the person hearing it, is not considered in the Constitution. The offense that you may take to someone's speech is not part of the equation. There's a speaker who visits a lot of campuses, Ben Shapiro. It's famous for saying, facts don't care about your feelings. Well, the First Amendment doesn't care about your feelings either, because everybody has feelings. And two people could hear the same thing and have different feelings about it. One may think it's good, one may think it's bad. It's just not the test that has ever been used. And these are not areas of the law that are in hot dispute. You always hear about the 5-4 decisions, and which way is Justice Kennedy going to go on this social issue or that social issue. On these First Amendment cases, there's not a lot of dispute on these things. It's usually pretty clear. What other speech is not protected? One that's been a problem in a lot of campuses. I don't know if it's been a problem at Vassar. I was a little worried it might be a problem tonight, but we seem to have a good audience, which is shutting down speakers. That is not protected. You do not, your free speech does not mean you get to silence somebody else by heckling them to the point that they can't carry on, that others can't hear. and that was the U.S. Supreme Court, many decisions on that, but I'll just read you from one, that speech, you can't burden it, the speech cannot be financially burdened, meaning someone covered by the First Amendment can't charge so much in a security fee, for example, that they in effect prevent you from speaking any more than it can be punished, banned, simply because it might offend a hostile mob. And the Tinker case, Tinker v. Des Moines, involved students wearing anti-Vietnam War wristbands, and that was held as protected speech. This is my whole point. Protected speech, the history of the First Amendment, is the history of protecting protesters. It's the history of protecting the counterculture. It's the history of protecting the progressive movement. There are many other cases that do that, and if you want to hear about all those cases, you'll have to take the LSATs and go to law school, but trust me on it, the law is crystal clear. You do not have the right to silence others. That's not your free speech. You don't have the right to take over a stage, which happens a lot, shouting people down. And and universities, at least public universities, must stop students from shouting at speakers. That's an obligation that they have to protect free speech. What about schools? Because now we're going to shift. I've just described to you everything that takes place kind of outside the gates. Okay? Now we're going to talk about schools. If you're a public entity, you're covered by the First Amendment. And that's why a lot of these rallies take place at public universities, because you have the full public protection there. Private schools have a lot more flexibility. It's not true that they have an absolute right to repress speech, but they have a lot of ability to do that because they're private. And how much right they have to suppress speech may depend in part on how private they are. But there's no question in my mind that Vassar, for example, unless there's something about how it's structured I'm not aware of, assuming it's your usual liberal arts private college structure, has some right to regulate speech on campus. And the question is, how much of that regulation do you really want? And that's what I was addressing earlier. Many private colleges, and this is where Vassar and others have in a sense voluntarily consented to the First Amendment. Many private colleges have issued commitments to free speech in their charters, in their rules, in their regulations. Vassar's college regulations at the website of the dean of the college, Vass says, and this could be held to be a contractual obligation of the college, or at least impose on the college some obligation to permit and allow and protect free speech. Vassar is dedicated to freedom of inquiry and the pursuit of truth and is vigilant in defending the right of individuals to free speech. Vassar has taken on that obligation. You as a student coming here are entitled to rely on that. Whether you can sue on it, you'll have to hire a lawyer. But the point is, that is a significant obligation that this campus has taken on to itself. The college, however, is also a community dedicated to the cultivation of an atmosphere in which all of its members may live and work free from tolerance, disrespect, or harassment. The college, therefore, defends free speech and also embraces the principle of civil discourse. In this regard, members of the college community accept constraints similar to those of parliamentary debate against personal attacks, against personal attacks, or against use of inflammatory language. Under the rule of civility, individuals within the community are expected to behave reasonably, use speech responsibly, and respect the rights of others. Genuine freedom of mind is not possible in the absence of civility. So clearly Vassar recognizes some level of right to speech here. I think this is in the same book, the college regulations, it says you have the right, the following rights and expectations apply to all Vassar students. You have the right to freedom of expression, and you are expected to exercise regard for the rights and sensitivities of others. You have the right to freedom of discussion, and you are expected to respect diverse opinions. So clearly, Vassar wants an inclusive campus, but it also recognizes the value of freedom of speech as part of freedom of intellectual thought. Should we forbid? So now you get from the could to the should. Could Vassar suppress speech? Yes, to some level it could. Should it? Again, going back to some of these cases, that anti-war protesters, others were those being upheld. The civil rights movement, multiple cases in which the rights of the civil rights movement protest were protected by the First Amendment. Edwards v. South Carolina, which was 185 churchgoers peacefully assembling at the Zionist Baptist Church in South Carolina, began marching against segregation. They were arrested for disturbing the peace. That was thrown out. That was considered a violation of their First Amendment rights. And the quote there is, "A function of free speech under our system of government is to invite dispute." To invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Speech is often provocative and challenging. It may strike at prejudices and preconception and have profound unsettling effects as it presses for acceptance of an idea. That is why freedom of speech is protected against censorship or punishment, unless shown to produce a clear and present danger of a serious, substantial evil that arises beyond public inconvenience, annoyance, or unrest. And there were many other similar cases that protected the civil rights movement in this country against people who considered that civil rights language hate speech and had the power, or so they thought, to silence it, but the court said otherwise. What is the solution to how a school like Vassar handles these competing values? The University of Chicago in 2015 issued something called the Chicago Principles, which was contained in a report of the Committee on Freedom of Expression. And they tried to strike that balance of protecting free speech within a university setting, in a private university setting, where the First Amendment doesn't strictly apply. The freedom to debate, and so here are their principles, some of them, I'm not going to read them all. The freedom to debate and discuss the merits of competing ideas does not, of course, mean that individuals may say what they wish, wherever they wish. The university may restrict expression that violates the law. I just read to you a whole bunch of expression that actually is not protected by the First Amendment, that falsely defames a specific individual, that constitutes a genuine threat. So if you phone in a bomb scare, that is not protected speech. Or harassment. Things that might be protected speech if you say them generally, if you use it to target a specific individual in a harassing and stalking manner, may now not be protected speech. That just unjustifiably invades substantial privacy or confidentiality, or that is incompatible with the functioning of the university. In addition, the university may regulate the time, place, and manner of expression to ensure that it does not disrupt the ordinary activities of the university. So they may require, if you want to hold an event, you've got to go to whatever office it is that hands out classrooms or rooms, so you don't have multiple people. You want to put up posters, and I will say, I've been told all of the posters for my event, or most of them were torn down. If you want to put down up posters, then you've got to go someplace and get it stamped, and I think you may have to be a student organization or something like that. Those are things the university can do. You can punish things for reasons unrelated to the content of the speech. And now this is not in the principles, but it's me ad-libbing here. If somebody graffitis what we would call hate speech, a swastika or something like that, on a wall, assuming the First Amendment applied, You can punish them for vandalism, that's a crime. For defacing property, for a whole lot of other things. Even if, when the First Amendment applies, you don't punish them for the content of the speech. Certainly, the university could enforce rules as to locations where things can be posted, can prohibit the scrolling of things. I seem to remember something in Vassar, I think just about every college has it, somebody in the lavatory etching in something nasty there. That's defacing property. I mean, that's a crime. And the person who did it should be punished. You have to consider, should they be punished for the idea or for the defacing? And you can pass all sorts of regulations that punish the crime, but don't punish the idea. Getting back to these principles, the Chicago principles, these are narrow exceptions to the general principle of freedom of expression. And it is vitally important that these exceptions never be used in a manner that is inconsistent with the university's commitment to a completely free and open discussion of ideas. This is getting back to the issue of that the law doesn't care about your feelings. That's not a constitutional measurement. You can't use your freedoms to try to silence others like that. In a word, the university's fundamental commitment is to the principle that debate or deliberation may not be suppressed because the ideas put forth are thought by some or even most members of the community to be offensive. As a corollary to the commitment to free speech, the university community must also act in conformity with the principles of free expression. And so these are some of the principles that people are considering. So in conclusion, and I do welcome when we get there the questions. I love the question and the answer. You can ask hard questions. Just don't ask math questions because I'm not good at math. In conclusion, here's what I hope you will consider. Don't be so quick to give up your speech rights on campus. Because the history of rights is once you give them up, they're much harder to get back. Choose freedom of expression as the default option, that people should be free to express themselves and say what they want, even if you don't like it, unless there's some really, really narrow, justifiable reason on a private campus to stop them from saying it. And that should be only the most extreme circumstances, and there should be some standard by which that is judged. And some people who get to judge it who are neutral and not involved in the issue. So that people are not discriminated against on the basis of their viewpoint. And use, like I said, content-neutral measures. You can stop people from spray painting things you don't like on campus because they're not allowed to spray paint without ever having to reach the concept of what the idea they spray painted was. Be more free on this campus than the rest of society, not less free. And when faced with the choice of solving a problem through less speech or more speech, I urge you whenever possible to choose more speech, to try to convince people they're wrong, to argue your case rather than to silence others. I thank you for listening. I hope I've given you some things to think about, and I certainly welcome questions.